My name is Anudit and today I'm gonna speak the Evidence Act from section 1 to 100 to the best of my ability. And the provisions are as follows. The Indian Evidence Act 1 of 1872, commencement date 15th March 1872. Preamble. Whereas it is expedient to consolidate, define and amend the law of evidence, it is enacted as follows. Part 1 of Relevancy of Facts, Chapter 1, Introduction. Section 1, subtitle Extent and Commencement. This Act may be called the Indian Evidence Act 1872. It extends to the whole of India. It applies to all judicial proceedings in or before any court, including court-martials other than court-martial convened under the Army Act, the Indian Naval Discipline Act, the Naval Discipline Act or the Air Force Act, but not to affidavits presented to any court or officer known to proceedings before an arbitrator, and it shall came into force on 1st day of September 1872. Section 2 is repealed by Section 2 and Schedule of Repealing Act 1938, Section 3 Interpretation Clause. In this Act, the following words and expressions are used in the following senses, unless a contrary intention appears from the context. Number 1, court. Court includes all judges and magistrates and all persons except arbitrators legally authorized to take evidence. Fact means and includes anything, state of things or relation of things capable of being perceived by senses and any mental condition of which any person is conscious. Relevant. A fact is said to be relevant to another when it is connected with the other in any of the ways referred to in the provisions of this act relating to relevancy of facts. Fact in issue means and includes any fact from either by itself or in connection with other facts, the existence, non-existence, nature or extent of any right, liability, disability asserted or denied in any suit or proceeding necessarily follows. Explanation. Whenever under the provisions of any law for the time being in force relating to civil procedure, any court records an issue of the fact to be asserted or denied is a fact in issue. Document means includes any matter expressed or described upon any substance by means of letters, figures or marks, or by more than one of those means intended to be used or which may be used for the purpose of recording that matter. Evidence means and includes all statements which the court permits or requires to be made before it by any witnesses in relation to matters of fact under inquiry. Such statements are called oral evidence. Statements are called oral evidence, and all documents including electronic records produced for the inspection of the court. Such documents are called documentary evidence. Proved. A fact is said to be proved when, after considering the matters before it, the court either believes that it exists or considers its existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it exists. Disproved. A fact is said to be disproved when, after considering the matters before it, the court either believes that it does not exist or considers its non-existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it exists. A fact is said to be not proved when it is neither proved nor disproved. And India means the territory of India.
Start.
Section 4 may presume. Whenever it is provided by this act that the court may presume a fact, it may either regard such fact as proved unless and until it is disproved, or may call for proof of it. Shall presume. Whenever it is directed by this act that the court shall presume a fact, it shall regard such fact as proved unless and until it is disproved. Conclusive proof. When one fact is declared by this act to be the conclusive proof of another, the court shall, on proof of one fact, regard the other as proved and shall not allow evidence to be given for the purpose of disproving it. Chapter 2 of Relevancy of Facts. Section 5. Evidence may be given of fact in issue and of relevant facts. Evidence may be given in any suit or proceeding of the existence or non-existence of every fact in issue and of such other facts as are hereinafter declared to be relevant and of no others. Explanation. This section shall not enable any person to give evidence of any fact which he is entitled to prove by any provision of the law for the time being in force relating to civil procedure. Section 6. Facts forming part of the same transaction. Facts which, though not in issue, are so connected with the fact in issue as to form part of the same transaction are relevant, whether they occurred at the same time and place or at different times and places. Section 7. Facts which are the occasion, cause and effect of fact in issue. Facts which are the occasion, cause, effect, immediate or otherwise, of a fact in issue and all relevant fact, or which constitute the state of things under which they happened or which afforded an opportunity for their occurrence or transaction are relevant. Section 8. Motive, preparation or previous and subsequent conduct. Any fact is relevant which shows or constitutes a motive or preparation for any fact in issue or relevant fact, and the conduct of any party or of any agent to any such party to any suit or proceeding in reference to such suit or proceeding, or in reference to any fact in issue therein or relevant thereto, and the conduct of any person, an offence against whom is the subject matter of the proceeding, is relevant. Whether if such conduct influences or is influenced by any fact in issue or relevant fact, and whether such conduct was previous and subsequent thereto. Explanation 1. The word conduct in this section does not include statements unless those statements accompany and explain the acts other than the statements, but this section is not to affect the relevancy of statement under any other section of this act. Explanation 2. When the conduct of any person is relevant, any statement made to him or in his presence and hearing which affects such conduct is relevant. Section 9. Facts necessary to explain or introduce relevant facts. Facts necessary to explain or introduce a fact issue or relevant fact, or which supports or rebuts any inference as suggested by any fact issue or relevant fact, or which establishes the identity of any person or thing whose identity is relevant, or fix the time and place under which any fact issue or relevant fact happened, or which shows the relation of parties between whom any such fact was transacted, is relevant insofar as they are necessary for that purpose. Section 10. Things said or done by a conspirator in reference to common designs. When there are reasonable grounds to believe that two or more persons have conspired to commit offense or any actionable wrong, anything said, done, or written by any one of such person in reference to their common intention after the time when such intention was first entertained by any one of them is a relevant fact, as against each of such person believed to so conspiring as for the purpose of proving the existence of the conspiracy, as well as for the purpose of showing that any such person was a party to it. Section 11. When facts not otherwise relevant become relevant. Facts not otherwise relevant are relevant if they are inconsistent with any fact and issue or relevant fact, or if by themselves or in connection with other facts they make the existence or non-existence of any fact and issue or relevant fact highly probable or improbable. Section 12. In suit for damages, facts tending to enable court to determine amount are relevant. In suits in which damages are claimed, facts which will enable the court to determine the amount of damages which ought to be awarded is relevant. Section 13. Fact relevant when right or custom is in question. Where the question is as to the existence of any custom or right, the following facts are relevant. Any transaction by which the custom or right in question was created, modified, claimed, recognized, asserted, or denied, or which was inconsistent with its existence, and particular instances from which the right or custom was claimed, recognized, or exercised, or in which its exercise was disputed, asserted, or departed from. Section 14. Facts showing the existence of any state of body or of mind, state of mind or of body or bodily feeling. Facts showing the existence of any state of mind, such as intention, knowledge, good faith, negligence, rashness, ill will, or goodwill towards any particular person, or showing the existence of any state of body or bodily feeling are relevant if the existence of any such state of mind or bodily feeling is an issue or relevant. Explanation 1. A fact relevant as showing the existence of a relevant state of mind must show that the state of mind exists, not generally but in reference to particular matter in question, but where upon the trial of a person accused of an offence, the previous commission by the accused of an offence is relevant within this section, the previous conviction of the person shall also be a relevant fact. Section 15. Facts bearing upon question whether an act was accidental or intentional. Where there is a question that whether an act was accidental or intentional or done with a particular knowledge or intention, the fact that the act formed part of a series of similar occurrences in each of which the person doing the act was concerned is relevant. Section 16. Facts showing the existence of course of business. When there is a question whether a particular act was done, the existence of any course of business according to which it naturally would have been done is relevant. Admissions. Section 17. Admissions is defined. An admission is a statement, oral or documentary or contained in an electronic form which suggests any influence as to any fact and issue or relevant fact, and which is made by any of the persons and under the circumstances referred to in section 18 to 20. Section 18. Admission by a party to proceeding or his agent. Statements made by a party to the proceeding or by any agent to any such party whom the court regards under the circumstances of the case as expressly or impliedly authorized by him to make them are admissions. by suitor in representative character. Statements made by parties to suits suing or sued in a representative character are not admissions unless they were made while the party making them held that character. And statements made by person interested in subject matter, any person who has any proprietary or pecuniary interest in the subject matter of the proceeding and who make their statements in the character of the person so interested, or persons from whom interest is derived, any person from whom the parties to suit have derived their interest in the subject matter of the suit are admissions while they are made during the continuance of the interest of the person making the statement. Section 20. Admissions by persons whose position must be proved as against party to suit. Admissions made by statements made by the persons whose position or liability it is necessary to prove as against a party to the suit are admissions if the statements would be relevant as against such persons in relation to such position or liability in a suit brought by or against them, and if they are made by the person making them occupy such position or is subject to such liability. 20 okay. 20. 21.
1 second.
Section 21. Admissions by persons expressly referred to by party to suit. Admissions, statements made by the persons to whom the party to suit has expressly referred to for information in relation to a matter in dispute are admissions. Section 21. Proof of admissions as against persons making them and by or on their behalf. Admissions are relevant and can be proved as against the person who makes them or his representative in interest, but they cannot be proved by or on behalf of the person who makes it or by his representative in interest except in the following cases. Number 1, an admission may be proved by or on behalf of the person making it when it is of such a nature that if the person making it were dead, it would be relevant as between third persons under section 32b. An admission may be proved by or on behalf of the person making it when it consists of a statement as to the existence of any state of mind or body relevant or in issue and made at or about the time when such state of mind or body existed and is accompanied by conduct rendering its falsehood improbable. An admission may be proved by or on behalf of the person making it if it is relevant, otherwise then is an admission. 22. When oral admissions as to the contents of document are relevant. Oral admissions as to the contents of document are not relevant unless the party proposing to prove it shows that he is entitled to give secondary evidence, or unless the secondary evidence of the contents of such documents, or unless the genuineness of a document produced is in question. 22a. When oral account admissions as to the contents of electronic record are relevant. Oral admissions as to the contents of electronic records are not relevant unless the genuineness of the electronic record produced is in question. 23. In civil cases, admissions in civil cases when relevant. In civil cases, no admission is relevant if it is made either upon an express condition that the evidence of it is not to be given, or under the circumstances by which the court can infer that the parties agreed together that the evidence of it should not be given. Explanation: this section is nothing in this section shall be taken to exempt any barrister, attorney, vakil or pleader from giving evidence of any matter of which he may be compelled to give evidence under section 126. 24. Confession caused by inducement, threat or promise when irrelevant in criminal proceeding, and a confession made by an accused person is irrelevant in a criminal proceeding if the making of the confession appears to the court to have been caused by an inducement, threat or promise having reference to the charge against the accused proceeding from a person in authority and sufficient in the opinion of the court that it would give the accused person grounds which would appear to him reasonable for supposing that by making it he would gain any advantage or avoid any evil of temporal nature in reference to the proceedings against him. 25. Confession to police officer not to be proved. No confession made to a police officer shall be proved as against the person accused of any offence. 26. Confession by accused while in custody of the police not to be proved against him. No confession made by any person whilst he is in the custody of a police officer unless it be made in the immediate presence of a magistrate shall be proved as against such person. 27. How much of information received from the accused may be proved, provided that when any fact is deposed to as discovered in consequence of an information received from a person accused of any offence in the custody of a police officer, so much of the statement, whether it amounts to a confession or not, as distinctly relates to the facts thereby discovered, may be proved. 28. Confession made after removal of impression caused by inducement, threat or promise are relevant. If such a confession as is referred to in section 24 is made after the impression caused by inducement, threat or promise has, in the opinion of the court, been fully removed, it is relevant. 29. Confession otherwise relevant not to become irrelevant because of promise of secrecy, etc. If such a confession is otherwise relevant, it does not become irrelevant merely because it was made under a promise of secrecy or in consequence of a deception practiced upon the accused person for the purpose of obtaining it, or when he was drunk, or because it was made in answer to the questions which he need not have answered, whatever may have been the form of those questions, or because he was not warned that he was not bound to make such confession and that evidence of it might be given against him. 30. Consideration of proved confession against the person affecting person making it and others jointly under trial for same offence. When more persons than one are being tried jointly for the same offence, and a confession made by any one of such person affecting himself and some other of such persons is proved, the court may take into consideration such confession as against such other persons as well as the person who makes such confession. Explanation. Offence in this section includes abatement of or attempt to commit offence.
Yes.
Section 31. Admissions not conclusive proof but may stop. Admissions are not conclusive proof of the matters admitted, but they may operate as a stoppage under the provisions given applicant. Statement by persons who cannot be called as witnesses. 32. Cases in which statement of relevant facts by persons who is dead or cannot be found, etc. is relevant. Statements, written or verbal, of relevant facts made by any person who is dead or cannot be found or has become incapable of giving evidence, or his presence cannot be procured by the court without an expense of amount or delay, which under the circumstances of the case appears to the court unreasonable, are themselves relevant facts in the following cases. Number 1, when it relates to the cause of death, when the statement is made by the person as to the cause of his death or as to any circumstances of the transaction which resulted in his death. In cases in which the cause of that person's death comes into question, such statements are relevant whether the person who made them was or was not at the time when they were made under the expectation of death, and whatever may be the nature of the proceeding in which the cause of his death comes into question, or is made in course of business, when the statement is made by such person as to the in the ordinary course of business, and in particular when it consists of any entry or memorandum made by him in books kept in ordinary course of business, or in ordinary course of business, or of an acknowledgement written or signed by him as to the receipt of goods, money, security or property of any kind, or of a document used in commerce written or signed by him, or of the date of a letter or other document usually dated, written or signed by him, or made against the interest of the maker, when the statement is against the pecuniary or proprietary interest of the person making it, or when, if true, it would expose him or would have exposed him to a criminal prosecution or to a suit for damages, or gives opinion as to a public right or custom or matters of general interest, when the statement gives the opinion of any such person as to a public right or custom or matters of public or general interest, of the existence of which, if it existed, he would have been likely to be aware, and then such statement was made before any controversy as to such a right, custom or matter had arisen, or relates to existence of relationship, when the statement relates to the existence of any relationship by blood marriage or adoption between persons as to whose relationship by blood marriage or adoption the person making the statement has special means of knowledge, and when such statement was made before the matter in question was raised, the matter in dispute was raised, or is made in will or deed relating to family affairs, when the statement relates to the existence of any relationship by blood marriage or adoptions between persons deceased and is made in any will or deed relating to the affairs of the family to which any such deceased person belonged, or is made in any family portrait or upon any tombstone, or is made in family pedigree or upon any tombstone, family portrait, or on such thing on which the statements are usually made, and when such statement was made before the matter in dispute was raised, or is made in any document relating to any transaction mentioned in section 13 clause A, when the statement is contained in any deed, will or other document as to any transaction which relates to any transaction as is mentioned in section 13 clause A, or is made by several persons and expresses feelings in relation to matter in question, when the statement is made by a number of persons and expressed feelings or impressions on their part relevant to the matter in question. Section 33. Relevancy of certain evidence for proving in subsequent proceedings the truth of facts therein stated. Evidence given by a witness in a judicial proceeding or before any person authorized by law to take it for the purpose of proving in a subsequent judicial proceeding or in a later stage of the same judicial proceeding the truth of facts which it states when the witness is dead or cannot be found or is incapable of giving evidence or is kept out of the way by the adverse party, or if his presence cannot be obtained by the court without an amount of expense or delay which under the circumstances of the case the court considers unreasonable, provided that the proceedings was between the same parties or their representatives in interest, and the adverse party in the first proceeding had the right and opportunity to cross-examine, and the questions in issue were substantially the same in the first as in the second proceeding. Explanation: a criminal inquiry or trial shall be deemed to be a proceeding between the prosecutor and the accused in the meaning of this section. 34. Statements made under special circumstances. 34. Entries in books of account including those maintained in electronic form when relevant. Entries in books of account including those maintained in an electronic form regularly kept in the course of business are relevant whenever they refer to a matter into which the court has to inquire, but such statements shall not alone be sufficient to charge any person with liability. 35. Relevancy of statements in relevancy of entry in public record or electronic record made by a public servant in the discharge of his official duty is itself a relevant fact. 36. Relevancy of statements in maps, charts or plans. Statements of fact in issue or relevant fact made in a published map or chart generally offered for public sale, or made in map or plan made by the authority of the central government or of any state government as to matters usually represented or stated therein as to such map, charts and plans are themselves relevant facts. 37. Relevancy of statements as to fact of a public nature contained in acts or notifications. Section 38. Relevancy of statements as to any law contained in law books. When the court has to form an opinion as to any law of any country, any statement of such law contained in a book purporting to be printed or published under the authority of the government of that country and to contain such law, and a report of a ruling of the courts of such country contained in a book purporting to be the report of such rulings is relevant. How much of a statement is to be proved? 39. What evidence to be given when the statement forms part of a conversation, document, electronic record, or book or series of letters or papers? So much of such evidence and no more of the statement, conversation, document, electronic record, book or series of letters or papers as the court considers necessary in that particular case to the full understanding and effect of the statement and of the circumstances under which it was made. Evidence shall be given of so much. Judgments of Court of Justice when relevant. Section 14. Previous judgment relevant to bar a second suit or trial. The existence of any judgment, order or decree which by law prevents any courts from taking cognizance of a suit or holding a trial is relevant when the question is whether such courts ought to take cognizance of such suit or to hold a trial. 41. Relevancy of certain judgments in probate, etc. jurisdiction. A final judgment, order or decree of a competent court in the exercise of probate, matrimonial, admiralty or insolvency jurisdiction which confers upon or takes away from any person any legal character, or which degrades any person to be entitled to any such character or to be entitled to any specific thing, not as against any specified person but absolutely, is relevant when the existence of any such legal character or the title of any such person to any such thing is relevant. Such judgment, order or decree is conclusive proof that any legal character which it confers accrued at the time when the judgment, order or decree came into operation, and that any legal character to which it confers any person to be entitled accrues to that person at the time when such judgment, order or decree declared that it has accrued to that person, and that any legal character which it takes away from any person seized at the time from which such judgment, order or decree declared that it had seized or should seize, and that anything to which it declares any person to be so entitled was the property of that person at the time from which such judgment, order or decree declared that it had been or should be his property. 42. Relevancy and effect of judgments, orders or decrees other than those mentioned in section 41. The judgments, orders or decrees other than those mentioned in section 41 are relevant if they relate to matters of public nature relevant to inquiry, but such judgment, order or decrees are not conclusive proof of that which they state. 43. Judgments, etc. other than those mentioned in section 40, 41, 42 are when relevant. The judgments, orders or decrees other than those mentioned in section 40, 41, 42 are not relevant unless the existence of any such judgment, order or decree is a fact and issue or relevant under some other provisions of this Act. 44. Fraud or collusion in obtaining judgment or incompetency of court may be proved Any party to a suit or other proceeding may show that any judgment which is relevant under section 40, 41 and 42 and which has been proved by the adverse party was delivered by a court not competent to deliver it or was obtained by fraud or collusion. Opinions of third persons when relevant. Opinion of experts. 45. When the court has to form an opinion upon point of a foreign science, art, or as to identity of any handwriting or finger impressions, the opinions of upon that point of persons specially skilled in such above mentioned things are relevant facts, and such persons are called experts. 45a. Examiner of electronic evidence. When in any proceeding the court has to form an opinion upon any matter relating to any information transmitted or stored in any computer resource or any other electronic or digital form, the opinion of any examiner of the electronic evidence referred to in 79A of IT Act is a relevant fact. Such examiner shall also be an expert. 46. Facts bearing upon opinions of experts. Facts not otherwise relevant are relevant if they support or are inconsistent with the opinions of experts when such opinions are relevant. 47. Opinion as to handwriting when relevant. When the court has to form an opinion as to the person by whom a document was written or signed, any person acquainted with the handwriting of the person by whom it is supposed to be written or signed that it was or was not written or signed by him is a relevant fact. Explanation: a person is said to be acquainted with the handwriting of another person when he has seen that person write, or when he has received documents purporting to be written by that person in answer to documents written by himself or any other under his authority and addressed to that person, or when in the ordinary course of business documents purporting to be written by that person have been habitually submitted to him. 48. 7a. Opinion as to electronic signature. When the court has to form an opinion upon the electronic signature of any person, the opinion of electronic certifying authority which has issued such electronic signature certificate is a relevant fact. 48. Opinion as to existence of right or custom. When the court has to form an opinion as to the existence of any general custom or right, the opinions as to the existence of such custom or right of persons who would likely to know of its existence if it existed are relevant. Explanation: the word custom and right includes custom or rights common to any considerable class of persons. 49. Opinion as to tenets, usages when relevant. When the court has to form an opinion as to tenets or usages of any body of men or family, and the government, the constitution and government of any religious or charitable foundation, and the meaning of words or terms used in particular districts or by any particular class of people, the opinion of persons having special means of knowledge thereon is a relevant fact. 50. Opinion as to relationship when relevant. When the court has to form an opinion as to the relationship of one person with another, the opinion as expressed by conduct as to the existence of such relationship of persons who, as a member of the family or otherwise, has a special means of knowledge on the subject is a relevant fact, provided that such opinion shall not be sufficient to prove a marriage in proceedings under the Indian Divorce Act 1869 or in prosecution under sections 494, 95, 97 or 98 of the IPC. 51. Grounds of opinion when relevant. When the opinion of living persons are relevant, the grounds on which the opinions are based are also relevant. Character when relevant. 52. In civil cases, character to prove conduct imputed is relevant. In civil cases, the fact that the character of any person concerned is such as to render probable or improbable any conduct imputed to him is irrelevant, except insofar as such character appears from facts otherwise relevant. 53. In criminal cases, previous good character is relevant. In criminal proceedings, the fact that the person accused is of a good character is relevant. 53a. Evidence of character and previous sexual experience is not relevant in certain cases. In prosecution for an offence under section 354, 354 ABCD or 376, 376A, AB, B, C, D, D, DB or E of the IPC, or for an attempt to commit any such offence, when the question of consent is an issue, the evidence of the character of the victim or of such person's previous sexual experiences with any person shall not be relevant on the quality of such consent or issue of such consent. 54. Previous bad character irrelevant except in reply. In criminal proceedings, the fact that the accused person has a bad character is irrelevant unless evidence has been given that he has a good character, in which case the evidence becomes relevant. It becomes relevant. Explanation 1. This section does not apply to cases in which the bad character of any person is itself a fact in issue, explanation to a previous conviction is relevant as an evidence of bad character. 55. Character is affecting damages. In several cases, the fact that the character of any person is such as to affect the amount of damages which he ought to receive is relevant. Explanation. In section 52, 53, 54 and 55, the word character includes both reputation and disposition, but except as provided in section 54, evidence may be given only of the general reputation and general disposition, and not of particular acts by which the disposition or reputation were shown. Part 2 on proof. Chapter 3, facts which need not be proved. Section 56, facts judicially noticeable need not be proved. No fact of which the court will take judicial notice need to be proved. Section 57, facts of which the court must take judicial notice. The court shall take the judicial notice of the following facts. Number 1, all laws in force in the territory of India, all public acts passed by the Parliament of the UK, all local and private acts passed by such Parliament if directed to be judicially noticed. All local and private Articles of War for Indian Army, Articles of War for Indian Army, Navy or Air Force, the accession and sign manual of the sovereign. All seals of all courts in India and outside India, if established by the authority of the central government, seals of all courts of admiralty and maritime jurisdiction, seals of notary publics, and seals for which any person is authorized to use by the Constitution or any act of Parliament having the force of law in India. And number 7, the accession to office, names, titles, functions, and signature of any person filling for the time being any public office in any state, if notified in the official gazette, the existence, title, and the national flag of every state and sovereign recognized by the government of India, the divisions of time and geographical divisions and public festivals, fasts, and holidays notified in the official gazette, the territories under the dominion of the government of India, the commencement, continuance, and termination of hostilities between the government of India and any other state or body of persons, the name of members and officers of the court and their deputies, subordinates, and assistant attorneys, vokis, proctors, and prisoners, etc., authorized to act before it, the rules on the road, the rule of the road on the land or at sea. In all these cases and on all matters of public literature, history, literature, science, or art, the court may resort for its aid to appropriate documents or books of reference. If any court is called upon by any person to take judicial notice of any fact, it may refuse to do so, unless and until such person produces such books or documents as it may consider necessary to enable it to do so. Section 58, facts admitted need not be proved. No fact need to be proved in any proceeding which the parties thereto or their agents agree to admit at the hearing, or which before the hearing they agree to admit by any writing under their hands, or which by any rule of pleadings in force at the time when they are deemed to have admitted by their pleadings, provided that the court may in its discretion require the facts admitted to be proved otherwise than by such admissions. Chapter 4 of Oral Evidence, Section 59, Proof of Facts by Oral Evidence. All facts except the contents of the documents or electronic records may be proved by oral evidence. 60. Oral evidence must be direct. Oral evidence must in all cases whatever be direct. That is to say, if it refers to a fact which could be seen, it must be the evidence of a witness who says he saw it. Or if it refers to a fact which could be heard, it must be the evidence of a witness who says he heard it. Or if it refers to a fact which could be perceived by any other sense or in any other manner, it must be the evidence of a witness who says he perceived it by that sense or in that manner. And if it refers to the opinion or to the grounds on which the opinion is held, it must be the evidence of the person who holds that opinion on those grounds, provided that the opinions of experts expressed in any treatise commonly offered for sale and the grounds on which such opinions are held may be proved by the production of such treatises. If the author is dead or cannot be found or is incapable of giving evidence or cannot be called as a witness without an amount of expense or delay which the court regards as unreasonable, provided also that if the oral evidence refers to existence or condition of any material thing other than a document, the court may, if it thinks fit, require the production of such material thing for its inspection. Chapter 5 of Documentary Evidence, Section 60. 1. Proof of contents by documentary evidence. The contents of documents may be proved by either by primary or by secondary evidence. 62. Primary evidence means the document itself produced for the inspection of the court. Explanation 1. Where a document is executed in several parts, each part is a primary evidence of the document. Number 2. When a document is executed in counterparts, each counterpart being executed by one or some of the parties only, each counterpart is primary evidence as against the party executing them. Explanation 2. Where a number of documents are all made by one uniform process, as in case of printing, photography or lithography, each of such part is the primary evidence of the contents of the rest, but where they are all the copies of a common original, they are not primary evidence of the contents of the original. 63. Secondary evidence means and includes certified copies given under the provisions of this Act, copies made from the original by mechanical processes which in themselves ensure the accuracy of the copy, and copies compared with such copies. Number 3. Copies made from or compared with the original, counterparts of the documents as against the parties who did not execute them, and oral accounts of the contents of documents by some person who has himself seen it. Section 64. Proof of document by primary evidence. The contents of documents must be proved by primary evidence except in cases mentioned in section 65. 65. Cases in which secondary evidence relating to contents of documents may be given. Secondary evidence may be given as to the existence, condition or contents of the documents in the following cases. Number 1. When the original is shown or appears to be in the possession or power of any person against whom the document is sought to be proved, or out of reach of or not subject to the process of the court or of any person legally bound to produce it, and when after the notice mentioned in section 66 such person does not produce it. B. When the existence, condition or contents of the original have been proved to be admitted in writing by the person against whom it is proved or his representative in interest, or when the original has been lost or destroyed, or when the party offering the evidence of its contents cannot for any other reason not arising from his own default or neglect produces it in a reasonable time, or when the original is of such a nature as to not to be easily movable, or when the original is a public document in the meaning of section 74, or when the original is a document of its certified copy is permitted by this act or by any other act by any other law enforced in India to be given in evidence, or when the original consists of numerous accounts or other documents and the fact to be proved is the general result of the whole of the collection. In case A, C and D, any secondary evidence is admissible as to the contents of documents is admissible. In case of clause B, written admission is admissible. In case of clause E and F, the certified copies but no other kind of secondary evidence is admissible. And in case of clause G, the evidence may be given as to the general result of the document by a person who has examined them and who is skilled in examination of such documents. 66. Rules as to notice to produce. Secondary evidence of the contents of document as referred to in clause 65 clause A shall not be given unless the party proposing to give such secondary evidence has previously given to the party in whose possession or power the document is, or to his attorney or pleader, such notice to produce it as is prescribed by law, and if no notice is prescribed by law, then such notice as the court considers reasonable under the circumstances of the case, provided that no such notice shall be necessary in order to render secondary evidence admissible in any of the following cases or in any other case in which the court thinks fit to dispense with it. Number 1. When the document to be proved is itself a notice, or when from the nature of the case the adverse party must know that he will be required to produce it, or when it is shown or proved that the adverse party has obtained the original by fraud or force, or when the adverse party or his agent has the original in court, or when the adverse party or his agent has admitted the loss of the document, or when the person in possession of the document is out of reach of or not subject to the process of the court. 67. Proof of handwriting and signature by person alleged to have signed or written the document produced. If a document is alleged to be signed or to have been written in wholly or in part by any person, any signature or writing of so much of the document as is alleged to be in that person's handwriting must be proved to be in his handwriting. Section 68.
Yes.
65 is section special provisions as to evidence relating to electronic record. The contents of electronic record may be proved in accordance with section 65B. 65B, admissibility of electronic records. This section facilitates the secondary evidence of the electronic record for the purpose of proving that if it is a document. Subsection 1. Any electronic record is when any electronic record is printed out and stored on any paper, and stored or prepare any record or copy through any optical or magnetic mode. Such record shall be treated as a computer output and it shall be deemed to be a document. Subsection 2 provides for conditions. If completed, any electronic record shall be treated as primary evidence of its contents. At number 1, at the time of its creation, the electronic record. At the time of the creation of electronic record, the computer that produced it must have been in regular use, and the person who has lawful possession on such computer shall use such information in ordinary course of business, and the kind of information stored in the computer must have been regularly and ordinarily fed into the computer, and the computer was operating properly throughout the said period when the information was stored in it, or if not in operation, was not as such to affect the electronic record or the accuracy of its contents, or any information contained in the computer output was procured from any information which was duly filled in the ordinary course of business, and the duplicate copy must be a reproduction of the original electronic record. Subsection 3. If any information is fed into the computer which is connected with more than one computer, then all such computers shall be treated as a same or single computer. Subsection 4 is computer certificate. To establish the authenticity of an electronic record, it requires the production of a certificate from an officer who is responsible for the computer in which the information is created or stored, and such certificate shall identify the original electronic record and describe the manner of its creation, identify the device used to produce the electronic record, and certify compliance with the technological conditions under section 65B, subsection 2. 5. For the purposes of this section, any information shall be taken to be supplied to any computer, whether it was supplied by any human interference or any appropriate equipment, and if such information was duly stored or supplied in a computer, shall be taken to have been supplied to it in the ordinary course of activities, and a computer output shall be taken to have been produced, whether it was produced by any human interference or by any appropriate equipment. 67A. Proof as to electronic signature. Except in case of a secure electronic signature, if the electronic signature of a person is alleged to have been affixed to an electronic record, the electronic signature is the electronic signature of the subscriber. It must be proved. 68. Proof of execution of documents required by law attested. Proof of execution of documents required by law to be attested. If a document is required by law to be attested, no evidence, it shall not be used as evidence unless one attesting witness at least has been called for the purpose of proving its execution, if there be an attesting witness alive and subject to the process of the court and capable of giving evidence, provided that no attesting witness shall be required to be called in proof for the execution of any document, not being a will which has been registered in accordance with the provisions of Indian Registration Act 1908, unless its execution by the person by whom it purports to have been executed is specifically denied. 69. Proof when no attesting witness found. If no such attesting witness can be found, or if the document purports to have been executed in the United Kingdom, it must be proved that the attestation of one attesting witness at least is in his handwriting, and the signature of the person executing the document is in the handwriting of that person. 70. Admission as to execution by a party to attested document. An admission by a party to an attested document of its execution by himself shall be sufficient proof as against such party, though it be a document required by law to be attested. 71. Proof where attesting witness denies the execution. If the attesting witness denies or does not recollect the execution of the document, its execution may be proved by other evidence. 72. Proof of document not required by law to be attested. An attested document not required by law to be attested may be proved as if it was unattested. 73. Comparison of signature, seal or writing with others, admitted or proved. In order to ascertain whether a signature, seal or writing is that of the person by whom it purports to have been written or made, any signature or writing purports to have been written or made by such person. Any signature, any writing, signature or seal admitted or proved to the satisfaction of the court to have been written or made by that person may be compared with the one which is to be proved. Though such signature, writing or seal is not produced or for any other purpose, is not produced or proved for any other purpose, the court may direct any person present in the court to write any figures or words for the purpose of enabling the court to compare the words or figures so written with any words or figures as is alleged to have been written by such person, provided that this section also applies with any necessary modifications to finger impressions. 73A. Proof as to verification of a digital signature. In order to ascertain whether a digital signature is that of the person by whom it purports to have been so affixed, the court may direct that person or the controller or the certifying authority to produce the digital signature certificate or any other person to apply the publicly listed in the digital signature certificate and to verify that the digital signature purported to have been affixed by that person. 74. Public documents. Following are the public documents: the documents forming the acts or record of acts of the sovereign authority, of official bodies and tribunals, of public officers, legislative, judicial and executive of any part of India or of the Commonwealth or of a foreign country, and public documents kept in any state of public records kept in any state of private documents. 75. Private documents. All other documents are private. 76. Certified copies of public documents. Any public officer having the custody of a public document which any person has a right to inspect shall give to that person on demand a copy of it and on payment of legal fees therefore, together with a certificate written at the foot of such copy that it is a true copy, and such certificate shall be dated and subscribed by the officer with his name and official title and shall be sealed whenever such officer is authorized by law to make use of a seal, and the copy so certified shall be called certified copies. Explanation: any officer who, by the ordinary course of official duty, is authorized to deliver such copies shall be deemed to have the custody of such documents in the meaning of this section. 77. Proof of documents by production of certified copies. Such certified copies may be produced in proof of the contents of the public documents or parts of the public documents of which they purpose to be copies. Section 78. Proof of other official documents. The following public documents may be proved as follows: acts, orders or notifications of the central or the state government or the town representative, by the records duly certified by the head of the department, or by the document to be printed by the order of the government, the proceedings of the legislature, by journals of such bodies, by published acts or abstracts, or by copies printed by the order of the government, the proclamations, orders or regulations of the Her Majesty or Privy Council or any department of Her Majesty's government, by copies or extracts contained in the London Gazette or printed by the Queen's printer, and acts or acts of executive or the proceedings of the legislature of a foreign country, by journals published by their authority, by copies made under the seal of the sovereign, and by a recognition in the Central Act. Number 5. Proceedings of municipal body in a state, by certified copies of such proceedings, or by printed book published by any competent authority of such body. And number 6. The public documents of any other class in a foreign country, by the original or by certified copies issued with certificate. Section 79. As to documents. Section 79. Presumption as to genuineness of a certified copy. The court shall presume to be genuine every document purporting to be a certificate or certified copy or other document which is declared by law to be admissible as an evidence of any particular fact and which is duly certified by any officer of the central or the state government or of any officer in the state of Jammu Kashmir who is duly authorized thereto by the central government, provided that the document is substantial in the form and executed in the manner directed by the law in that behalf, and the court shall also presume that any officer by whom any such document was certified or signed held when he signed it the official character which he claims in such papers. Section 80. Presumption as to documents produced as record of evidence. Whenever any document is produced before any quote, purporting to be a record or memorandum of the evidence or of any part of evidence given by a witness in a judicial proceeding or before any officer authorized by law to take such evidence, or to be the statement or confession of any prisoner or accused person taken in accordance with law and purporting to be signed by any judge, magistrate, or by any such officer as aforesaid, the court shall presume that the document is genuine, that the statement as to any circumstances under which it was taken purporting to be made by the person signing it are true, and that the evidence, statement, or confession was duly taken. 81. Presumption as to gazettes, newspapers, private acts of parliament, and other documents. The court shall presume the genuineness of every such document if such document is kept substantially in the form required by law and is produced from proper custody. 81A. Presumption as to gazettes in electronic forms. The court shall presume the genuineness of every such electronic record if such electronic record is kept substantially in the form required by law and is produced from proper custody. 82. Presumption as to documents admissible in England without proof of signature or seal. So the court shall presume that such signature, stamp, or seal is genuine, and that the person signing it at the time when he signed it held the judicial official character which he claims, and the document is admissible for the same purpose for which it would be admissible in England or Ireland. 83. Presumption as to maps or charts made by authority, maps or plans made by authority of government. The court shall presume that any map or chart made by the authority, by the central government or of a state government was so made and are accurate, but maps or charts made for purposes of any cause must be proved to be accurate. 84. Presumption as to collection of laws and the records of reports of decisions. The court shall presume the genuineness of every book purporting to be the court shall presume the genuineness of that country. Every book purporting to be any laws of any country and to contain such laws, and every book purporting to contain records of the decisions of the courts of such country. Section 85. Presumption as to powers of attorney. The court shall presume that every document purporting to be a power of attorney and to have been executed before and authenticated by any notary public or any court, judge, magistrate, Indian council or vice council or any representative of the central government was so executed and authenticated. 85A. Presumption as to electronic agreements. The court shall presume that every electronic record purporting to be an agreement containing the electronic signature of the parties was so concluded by affixing the electronic signature of the parties. 85B. Presumption as to electronic record and electronic signature. In any proceeding involving the secure electronic record, the court shall presume, unless contrary is proved, that the secure electronic record has not been altered since the specific point of time to which the secure status relates. Subsection 2. In any proceedings involving the secure electronic signature, the court shall presume, unless the contrary is proved, that the secure electronic signature is affixed by the subscriber with the intention of signing or approving it, and except in the case of a secure electronic record or secure electronic signature, nothing in this section shall create any presumption relating to any authenticity and integrity of the electronic record or any electronic signature. 85C. Presumption as to electronic signature certificate. The court shall presume, unless the contrary is proved, that the information listed in an electronic signature certificate is correct, except for information specified as subscriber information which has not been verified if the certificate was accepted by the subscriber. 86. Presumption as to certified copies of foreign judicial reports. The court may presume that any document purporting to be any certified copy of any judicial record of a country not forming the part of India or of Her Majesty's dominions is genuine and accurate if the document purports to be certified in the manner which is certified by the representative of the central government in or for such country to be the manner commonly used in that country for the certification of copies of judicial reports. 87. Presumption as to books, maps, and charts. The court may presume that any book to which it may refer for information as to matters of public nature and any published map or chart, the statement of which are relevant fact and which is produced for its inspection, were written and published by the person and at the time and place by whom or at which it purports to have been written or published. 88. Presumption as to telegraphic messages. The court may presume that a message forwarded from a telegraphic authority to the person to whom the message purports to be addressed corresponds with a message delivered for transmission at the office from which the message purports to be sent, but the court shall not make any presumption as to the person by whom such message was delivered for transmission. 88A. Presumption as to electronic messages. The court may presume that an electronic message forwarded by the originator through an electronic mail server to the addressee to whom the message purports to be addressed corresponds with a message as fed into his computer for transmission, but the court shall not make any presumption as to the person by whom such message was sent. 89. Presumption as to execution, due execution, etc. of documents not produced. The court shall presume that every document called for and not produced after notice to produce was duly attested, stamped, and executed in the manner required by the law. 90. Presumption as to documents 30 years old. Where any document purporting or proved to be 30 years old is produced from any custody which the court in the particular case considers proper, the court may presume that the signature and every other part of such document which purports to be the handwriting in the handwriting of any particular person is in that person's handwriting, and in the case of a document executed or attested, that it was duly executed and attested by the person by whom it purports to have been executed and attested. Explanation. Document is said to be in proper custody if they are in the place in which and under the care of the person with whom they would naturally be, but no custody is improper if it is proved to have had a legitimate origin or if the circumstances of the case are such as to render such an origin probable. 90A. Presumption as to electronic records 5 years old. Where any electronic record purporting or proved to be 5 years old is produced from any custody with the court in the circumstances of the particular case considers proper, the court may presume that the electronic record which purports to be the electronic record of any person was so affixed by him or by any person authorized by him in this behalf. Explanation. An electronic record is said to be in proper custody if they are in the place in which and under the care of the person with whom they would naturally be, but no custody is improper if it is proved to have had a legitimate origin or if the circumstances of the case are such as to render such an origin probable. 91. Chapter 6 of the exclusion of oral by documentary evidence. 91. Evidence of the terms of contract, grant, or other disposition of property reduced to the form of a document. When the terms of a contract or of a grant or of any other disposition of property and in all cases in which any matter is the terms of the contract or of a grant or of any other disposition of property have been reduced to the form of a document, and in all cases in which any matter is required by law to be reduced to the form of a document, no evidence shall be given in proof of the terms of such contracts, grants, or other disposition of property except the document itself or secondary evidence of its contents in cases in which the secondary evidence is admissible under the provisions before contract. Exception 1. Where a public document is required by law to be where a public officer is required by law to be appointed in writing, and it is shown that any particular person has acted as such officer, the writing by which he is appointed need not be proved. Exception 2. Wills admitted to probate in India may be proved by the probate. Explanation 1. This section applies equally to the cases in which contracts, grants, and other disposition of property referred to are contained in one document, and in cases when they are contained in more documents than one. Explanation 2. When there are more originals than one original only need be proved. Explanation 3. The statement in any document whatever of a fact other than the facts referred to in this section shall not preclude the admissions of oral evidence as to the same fact. 92. Exclusion of evidence of oral evidence. When the terms of such contract, grant, or other disposition of property and in any matter which is required by law to be reduced to the form of a document, no evidence of any oral agreement or statement shall be admitted as between the parties to such instrument or their representatives in interest for the purpose of contradicting, varying, adding to, or subtracting from its terms. Proviso 1. Any fact may be proved which would invalidate the document or which would entitle any person to any decree or order relating thereto, such as fraud, intimidation, illegality, want of due execution, want of capacity in any contracting party, want or failure of consideration, or mistake in fact or law. 2. The existence of any separate oral agreement as to any matter on which a document is silent and which is not inconsistent with its terms may be proved, and in considering whether or not this section applies, the court shall have regard to the degree of formality of the document. 3. The existence of any separate oral agreement constituting a condition precedent to the attaching of any obligation under any such contract, grant, or disposition of property may be proved. Number 4. The existence of any distinct subsequent oral agreement to rescind or modify such contract, grant, or other disposition of property may be proved except in cases in which such contract, grant, or other disposition of property is by law required to be in writing or has been registered according to the law in force for the time being as to registration of documents. Proviso 5. Any custom or usage by which incidents not usually not expressly mentioned in the contract are usually annexed to the contracts of that description may be proved, provided that the annexing of the incidents would not be repugnant to or inconsistent with the express terms of the contract. Proviso 6. Any fact may be proved which shows in what manner the language used in the document is related to existing facts. 93. Exclusion of evidence to define or amend ambiguous documents. The language used in a document is on its face. When the language used in a document is on its face ambiguous or defective, evidence may not be given of facts which would show its meaning or supply its defects. 94. Exclusion of evidence against application of document to existing facts. When the language used in a document is plain in itself and when it applies accurately to the existing facts, evidence may not be given to show that it was not meant to apply to such facts. 95. Evidence as to the document unmeaning in reference to existing facts. When the language used in a document is plain in itself but is unmeaning in reference to existing facts, evidence may be given of facts to show that it was used in a peculiar sense. 96. Evidence as to the application of language which can apply to one only of several persons. When the facts are such that language used might have been meant to apply to anyone and could not have been meant to apply to more than one of several persons or things, evidence may be given to show that to which of those several persons or things it was intended to apply to. 97. Evidence as to the application of language to one of two sets of neither to which the whole correctly applies. When the language used in a document, when the language used applies to one set of, partly applies to one set of existing facts and partly applies to another set of existing facts, but the whole of it does not apply correctly to either, evidence may be given of facts to show to which of the two it is meant to apply. 98. Evidence as to the meaning of illegible characters, etc. Evidence may be given to show the meaning of illegible or not commonly intelligible characters of foreign, obsolete, technical, local, and provincial expressions of abbreviations and of words used in a peculiar sense. Section 99. Who may give evidence of agreement for varying the terms of the document. Persons who are not parties to a document or their representatives in interest may give the evidence of facts tending to show a contemporaneous agreement for varying the terms of the document. Section 100. Provisions, savings of provisions of Indian Succession Act relating to this. Nothing in this chapter contains shall affect any of the provisions of Indian Succession Act as to the construction of the wills.
Please clapping for Anudit.